today. This is one of our first conferences since 2020, so it's nice to see everyone again. My name is Nipa again, and I work as a hotline specialist for Housing Court Answers, and I will be moderating the conference today. So on today's schedule, we will have two sessions. Our first session will be a presentation by Mr. Dereck Frederick from DHCR on what happens when a rent overcharge is filed with DHCR. We will also have Seth Miller, our partner from Collins, Dopkins, and Miller LLP, to discuss how to read rent histories, in addition to decide what is the appropriate venue to file a rent overcharge. Then we will have a short break before our second section, where we will have our very own Housing Court Answers staff, Kayla, Popuchet, and Alexander Chaparro, who will present a workshop on how to help unrepresented tenants. Just some ground housekeeping rules. We ask that you please keep yourself muted at all times during the presentation. If you have any questions, they will be answered after the speakers have finished with their presentation. So please add your questions in the chat after they are done speaking so we do not miss them. We cannot answer any questions related to a specific case, but if you need help with a specific case, please feel free to call the HCA hotline at 212-962-4795 for further assistance. And we will, again, put that number in the chat box. We do have legal service providers that we can connect you with if you require legal advice, so feel free to reach out to us. However, for today, we will only be taking general questions. Just to let everybody know, this meeting will be recorded and shared on our website along with our YouTube page, so you can feel free to check it out if you've missed anything. Along with other presentations we have hosted prior, I will be sharing that link for our workshop and YouTube page in the chat. And we will be sharing the materials presented today. So just going to give people just 2 more minutes, just because we have still have a couple of people coming in before we begin. Okay, so we will begin with our first presenter. First, we will be hearing from Mr. Dereck Frederick, who is the Director of Borough Rent Operations at DHCR. He will be talking about what happens when DHCR receives a rent overcharge complaint and the process that takes place. Mr. Dereck has been with DHCR for over 20 years, starting as a rent examiner in the Overcharge unit. He is currently the Director of BRO Operations. He manages the 6th BRO and the district rent offices located throughout New York City and in White Plains. He also oversees the online information portals as well as the rent info line where the public can call for assistance. So we thank Mr. Dereck for coming and giving this presentation today, and I will turn it over to him.
Thank you, Nipa. Okay, so I'm going to start by sharing my screen. Can you enable it, please? It says it's disabled.
Sure.
Okay, thank you. Okay, so today what I'm going to do is just give an overview of overcharge, starting from who can actually file an overcharge, some of the things we look at in overcharge, the types of notices that are involved, as well as the different forms of evidence. Starting with who can file an overcharge. Generally, tenants who believe that they're being overcharged basically can file. Tenants no longer in occupancy can also file, provided the alleged overcharge occurred within a look-back period, which is currently 6 years. Now, what happens when a tenant files is that we will establish what the legal regulated rent is, and we may order owners to lower the collectible rent and refund any excess rent collected based on our finding of rent overcharge. The orders are issued based on a preponderance of the evidence provided by both the owners and the tenants. Roommates can also file rent overcharge complaints based on their proportional share of the rent. For example, if there are two roommates and only one is named on the lease, but the other one is occupying as a roommate, their portion of the rent should only be 50%. Now, in those cases, while there may not be any penalties involved, we will order that any excess rent be refunded to that roommate. Subtenants are also allowed to file overcharge complaints. Other than a 10% allowance for fully furnished apartments, the prime tenant who is subleasing their apartment cannot charge more than the lawful rent. They can't ask for any key monies or anything else. And if we do find that a subtenant is overcharged, that prime tenant could be assessed treble damages on that overcharge. The Tenant Protection Unit, TPU, is also able to initiate overcharge complaints. Now, while they are separate and apart from ORA, they, as part of their function, can proactively start an overcharge complaint. Now, once they do that, the tenant who's in occupancy, if they're in occupancy, is notified that TPU has initiated an overcharge complaint, and they're given the option to join into the complaint. Once the overcharge is adjudicated, they would get any proceeds of that overcharge complaint, provided that they are still in occupancy. If they've already vacated or were not in the apartment at the time that the overcharge was initiated, or based on when the overcharge occurred, they would not receive that overcharge directly. Any tenant who is in the apartment at the time that the order is issued, if they are not the tenant involved in the overcharge, would receive a copy of the order, and that could be useful to them if they in turn wanted to file their own overcharge complaint based on a resetting of the legal regulated rent. Both parties have a right to appeal an overcharge order. It has to be filed within 35 days of the order being issued. It has to be sent directly to the office where the cases are processed, which is Gertz Plaza. They also can be hand delivered there. While the overcharge is being appealed, the tenant cannot collect any back rent or damages due during that time. They can, however, continue to pay the lower rent if that's what was established in the overcharge complaint while the PAR is pending. Now, there are different types of overcharges. In general, a normal overcharge is just based strictly on being charged more than the legal rent. And it could be something as simple as a new tenant moves in, previous tenant was paying $950, the owner gave them a lease for $1,200, isn't claiming any individual apartment improvements or other reasons for why there's a disparity in the rent. They're just straight overcharging the tenant. There are also what's known as specific overcharges, such as if the owner is charging for an AC that they're not entitled to charge, if they're charging for a late fee, excess security, those would be considered specific overcharges. And when there's a specific overcharge, there is no review of the underlying rent or rent history in determining that case. We will only look at that specific item that the tenant is claiming as a specific overcharge. So if, as I said, it's a late fee, we will only look to see whether or not the owner is legally entitled to charge that late fee. And if so, or if not, we would direct the owner to refund any late fees that were collected from the tenant, but there will not be a rent calculations chart or any other determination on the base rent. There are other types of overcharges that could include MCI or individual apartment increases incorrectly calculated. We also look at overcharges that are a result of previous orders that haven't been complied with. Types of previous orders that I'm talking about is if you are a tenant that has just moved into an apartment and maybe a previous tenant had filed for a rent reduction due to decrease in services, they received that rent reduction due to decrease in services and moved out, the owner never either fixed the underlying issues and requested a restoration or just ignored the service reduction order, and then you subsequently find out that that order is still in effect, you could file a rent overcharge complaint based on the fact that the owner is collecting more than they're entitled to. It also could be the result of a previous overcharge order that lowered the legal regulated rent, and you as a new tenant moving in would not be aware of, and the owner is charging you more than they should be based on that previous order. There are also, and this is very common, overcharges that are brought to us based on the calculation of preferential rents. And the thing with preferential rents is that under the Housing Stability and Tenant Protection Act, there is a line of demarcation on preferential rents before and after that act. So they would be treated a little differently, and when the tenant files, how we would process that case would be determined based on whether or not that preferential rent came before or after the enactment of the Housing Stability and Tenant Protection Act. So now I'm going to talk about some of the common notices that we send out. And if time permits at the end, I will show you examples of these various notices. The first notice that's sent out is the docketing and acknowledgement notice. And that's sent to the tenant or their representative, and it notifies them that the complaint's been received, we've issued a docket number, and gives instructions on how to correspond with the agency. The next thing that happens is there's a notice and transmittal of the tenant's complaint, and that's sent to the owner. It will include a copy of the tenant's complaint and documents that we may request from the owner, and give them a time limit on replying to that initial notice to respond to the tenant's complaint. The next thing that usually happens in these cases, after a case is assigned, is we may send out notices requesting additional information and evidence. And these can be sent to either party, either the tenant or the owner, depending on what the allegations are, what evidence was initially submitted when the case was filed, and what subsequent evidence we may need in order to look at and determine whether or not an overcharge has happened. What also happens during this course is that when we receive additional information and evidence, a copy of that is sent to the opposing party for their comment and response. It's part of what we call our due process system, which I'll mention later, whereby we have to give both parties equal opportunity to respond to notices and to respond to evidence entered by the other party. Another frequent notice is just a straight request for rental payments. Cases are filed, they're assigned. Usually by the time they are assigned, some time has elapsed, and we would need updated information from the tenant regarding how much rent they've been paying in the interim. Now, the answer to notice and our application is a general purpose form that we use if we need to clarify something, if we have to answer a question. It's also a form that's used by tenants to respond to information that's sent to them, or owners to respond to information that's sent to them from the other party. Another form is the request for confirmation of withdrawal of complaint. And this form is very important because whenever we receive from a tenant a request to withdraw their complaint, we always follow it up with this form to confirm that they actually are wanting to cancel their complaint and withdraw their application. And that way, we're assured that this is what the tenant or the representative actually want to do, that they want to discontinue this process so that we can verify that that is where they're going. Another very important notice is a final notice to owner and imposition of treble damages. Now, this notice is sent to owners or their representatives, and it advises them that we've processed the complaint. At that time, we've determined that there has been an overcharge. We are giving them a final opportunity to submit any evidence they have to prove that there was no overcharge. So if up until that point they hadn't sent in adequate documentation, this is, generally speaking, their last opportunity during this part of the process to submit some sort of evidence. If, based on our calculations, the overcharge is in excess of $25,000, this form is always sent by certified mail. Now I'm just going to go over just some general information about overcharges. Currently, the base date or look-back period is 6 years prior to the filing of a complaint. And that is for complaints filed after the passage of the Housing Stability and Tenant Protection Act. For cases filed prior to that Housing Stability and Tenant Protection Act, the look-back period is only 4 years. So that's somewhat of a two-tiered system, but it's based on a court decision. And so that is the look-back period that we would be dealing with if a complaint is filed right now. But if it's a complaint that's already in the system that was filed prior to the Tenant Protection Act, then we would only go back 4 years. Other than the previously mentioned specific overcharge cases, a rent calculations chart is always included in the overcharge order. And as I said before, if time permits, I'll show you an example of the chart. And this is whether there is a finding of rent overcharge or not. It shows how the legal rent was calculated. It shows what the collectible rent was, as well as what the tenant actually paid, and it calculates any finding of overcharge, including penalties due to the tenant. As I said earlier, we have due process requirements. And again, we are a quasi-judicial agency, meaning our orders can be enforced as a judgment. Because they can be enforced as a judgment, we have to follow due process rules and requirements, which basically gives both parties an opportunity to submit evidence to support their claims. Now, there are two ways that tenants can collect an overcharge. One is the offset method, which is basically deducting a portion of the monies owed in an overcharge from your monthly rent. The other method is the filing of a judgment. Now, the offset method would only apply to a tenant who is still in occupancy. If the tenant is vacated or has filed the overcharge complaint after they've already vacated the apartment, they would not be eligible naturally for the offset method, and they would only be able to use the judgment method. As part of the judgment method, there's a specific form called an RN14, Notice of Certification of Overcharge Penalties, that is required to be submitted by the tenant, wherein we certify that the order is accurate and that there are no pending appeals, or that the owner has exhausted all of their rights to appeal. And that would mean they either didn't file a petition for administrative review and the filing period is expired, or they filed and they were denied, and maybe they took it further and filed an Article 78, which is a separate type of appeal, which doesn't involve the tenant directly, but we certify that all of their appeals have been exhausted, and then the tenant is eligible to file it as a judgment with the county clerk's office and have it collected that way. Going back to the occupying tenant, though, once they decide to use the offset method, they can no longer use the judgment method once they start deducting monies from their rent. So they have to make a decision at that time which one they want to use, because once they use that offset, that method for judgment is no longer applicable to them. Now, there are different factors that can impact case processing. Those factors can include extension requests, ownership changes, requests for inspection, court decisions, and building or apartment status disputes. Now, extension requests, they can be made by either party. Generally, that just means that you're asking for more time to either submit certain evidence that's been requested or more time to respond to information that's been sent to you from the opposing party that you want to be able to have additional time to respond to. The normal extension that we give is 21 days. We normally do not notify the other party that one party has requested an extension. We just will either grant or deny the extension and go from there. Changes in ownership will require that we reserve all of the previous information as well as possibly requesting new information from that current owner. One thing that you have to keep in mind is that even when there is a change in ownership, the current owner of the apartment becomes solely responsible for overcharges, even if they occurred prior to their taking ownership of the building. So with that said, and without due process requirements, everything that we have previously done during the processing of the overcharge, we would essentially need to start again by serving all of that information to the new owner and giving them an opportunity to respond and submit whatever evidence that they have. Now, inspections is another thing that will greatly impact the case processing. Inspections will sometimes be needed when there are disputes over things that frankly can be inspected, such as if you're a new tenant, you've moved into the apartment, the owner's claiming that he made X amount of improvements, you're disputing that, and you may request that we send an inspector to look to see that the owner did not in fact put in new cabinets, did not in fact put in a new refrigerator, or what have you. So that's a process that takes it somewhat a little bit out of the overcharge unit, puts it in the inspection unit until the inspection is completed, and then it goes back into the overcharge unit once the examiner makes that request for an inspection. Court decisions are very important. Pending court decisions sometimes put a hold on processing cases that are affected. When we have a situation where, and this typically happens when there's a change or update in law, or there's a challenge to a part of the rent regulations, or even a challenge to the way that we enact policy as a result of rent regulations, we have to take all the cases that could be impacted by that court's decision and hold those cases in abeyance until that decision comes out. Some of the types of court cases we've dealt with, one of the more prevalent ones was Robert's case, which dealt with J51 apartments being deregulated while the building was still receiving benefits, and it was determined that they could not be deregulated while they were receiving benefits. And while that case was being adjudicated, all of the cases that involved J51 buildings and deregulation had to be held in abeyance. Another one is Grimm versus the HCR, which dealt with fraudulent deregulation and whether or not the agency would be allowed to look at it, even if it went beyond our look back period, which, as I said before, would be either 6 or 4 years. And it was determined that, yes, if deregulation was possibly fraudulent, the agency did have the ability to go back and investigate that deregulation to see if it was lawful, even if it was beyond the 4 or 6 year look back period. The other thing that impacts case processing are disputes over the building or the apartment status. And what happens in those cases is that before we can begin to process whether or not the rent is overcharged, we must first deal with the regulated status of the building. It's not possible for us to render a decision on whether or not a tenant is being overcharged unless we actually know that the tenant is subject to rent regulation. And some of the types of issues that could be in dispute would be if the owner alleged that the building was no longer subject to rent regulation because of a substantial rehabilitation of the building. We would have to process that first, make a determination, which was called an administrative determination, as to one way or the other whether or not the building is subject, and then proceed from there. Another situation that comes up is if the owner did or did not properly notify a tenant of a expiring tax benefit under J51. There is a specific procedure that an owner has to follow in order to deregulate an apartment once those benefits expire. And if a tenant files an overcharge and alleges that the owner did not follow the proper procedure, that has to be determined first before we can go any further with determining whether or not that tenant was overcharged. Now I'm going to talk about the different types of evidence that we look at in overcharge proceedings. First thing we will look at are leases. We always ask tenants to submit copies of their leases, not only for the rents that were paid, but also any lease clauses that I'll talk about in a minute. We ask for cancel checks. Cancel checks are very important in determining what did the tenant actually pay during the disputed period. Rent receipts given by the owner are also very important because that is almost an acknowledgement by the owner of what the tenant gave them, and goes a long way in augmenting the tenant's side. We take other forms of proof that the rent was paid. This could include copies of money orders, redacted bank statements showing the amount of rent that was paid, or any other documentation that a tenant could have that would substantiate what they actually gave the owner during that period. And as you'll see on the rent calculations chart, that is one of the things we look at. We look at the actual rent paid, we look at what the legal rent that we established, and then we look at what the owner was actually allowed to collect. We look at lease clauses. This is very important in cases, in specific overcharge cases involving like late fees, whether or not there's a clause in the lease allowing the owner to collect the late fee helps us in determining whether or not that is an overcharge. Under preferential rents, there are certain preferential rent clauses that have to be included in the lease when an owner is giving a tenant a preferential rent. There are clauses dealing with MCIs. If you are a new tenant moving into an apartment, and if there is already a pending MCI on that building, the owner has to notify you within the lease of that pending MCI. If he does not, that could result in an overcharge once that MCI becomes eligible to be collected. We also require thorough documentation of apartment improvements. Anytime an owner alleges that they did individual apartment improvements, and this is either pre or post the Housing Tenant Protection Act, he must provide us with specific documentation tied to that specific apartment, which would include canceled checks, itemized invoices, any sort of contract between them and the people who either did the renovations or supplied the new equipment. All of this must be thoroughly documented. It's very important in just regular II complaints. It's very important in situations where an owner is claiming to have been able to deregulate an apartment pre-HESPA, if that was part of how the rent was raised so that he could legally vacancy deregulate it. Anything like that, the owner has to thoroughly document that information. So now I'm just gonna give you some resources and then go over those forms that I talked about earlier. Our website is hcr.ny.gov. Our information line is 833-499-0343. You can log on to our portal. You can go into our portal and submit a question. And the question could be a general question. It could be inquiry as to whether or not you think your apartment should be rent stabilized. It could be a request for a rent history. But through that portal, you can ask us questions. Our general contact information is hcr.ny.gov/contact-us. So that's the general overview of the overcharge unit. So now I would like to, if I can go back and change the share screen and just show you some of the forms. There we go. That I discussed. Okay, so this first form is the docketing and acknowledgement notice. It gives you the docket number, the issue date, and this is redacted because it's an actual form that went out to a tenant. Here's our address. Again, it gives the docket number, and it states basically that it acknowledges the receipt of their complaint. It was assigned a docket number above and indicates who and how you should correspond and to notify us to the overcharge unit. The next form is the notice and transmittal of tenant's complaint of overcharge. Now, this is the form that goes to the owner once the complaint has been docketed and we start the process of gathering information. It notifies the owner that the tenant has filed their complaint, encloses the complaint form from the above alleged tenant. It advises the owner to review the complaint in its entirety. It makes them aware of the fact that if we do find that they overcharge a tenant, that they would be subject to treble damages. And it gives them 30 days to respond to that notice. The next form is just a request for additional information. This can go to either the owner or the tenant, has their address. It indicates that we're attaching a copy of information or evidence submitted by the other party, and it gives them a time period in which to respond to the information that was sent to them. This is what our request for rental payments looks like. Quite naturally goes to the tenant. It specifically asks for information during a specific period, and that would be the period that the tenant was alleging that they were overcharged. It asks them to send anything that they have, such as canceled checks, rent receipts, etc. This is a general answer to notice or application form. It can be used really by either party, and it's just a blank form that they can be used to either submit evidence or attach to a response to evidence that was submitted by the other party. As I said before, we have a specific form to confirm whether or not a tenant is actually withdrawing their complaint, and this is that form. It's addressed to the tenant or their representative. It shows that we are attaching a copy of whatever correspondence we received withdrawing the complaint, and then they just have to affirm whether or not they actually wish to withdraw their complaint or application, and if they do so, then the case would be closed without action. This is our treble damage notice. This is the notice that I previously mentioned would be the final notice sent to the owner, where we feel that we've established that there was an overcharge. Basically says, based on a record, that we find that there has been an overcharge in this matter. We set forth what the calculation of the overcharge is, and we give them an opportunity to submit evidence that they did not overcharge the tenant. This is the worksheet that is part of the form that shows how we calculated the overcharge and what the totals of the overcharge are. Finally, this is a redacted rent calculations chart. And this is a chart that accompanies every overcharge order. In this case, there was a finding of rent overcharge. You can see in the upper right-hand corner, we calculated the overcharge, we applied treble damages, and we totaled what that overcharge amount was. On the left side, we gave the base legal regulated rent. That's what LRR means. It's not a great copy. I apologize for that. But we did establish what the base legal regulated rent is, and we established the base collectible rent. The chart then shows what the tenant actually paid, when the rent changed, what the legal regulated rent was at that time, and what the collectible rent was. And as you go down the chart, when we get to the period where the tenant was overcharged, you start to see the calculations of what those overcharges are, the specific amount of overcharge times the number of months of the overcharge, and all of that, along with the footnotes, go along with the order assessing the overcharge, and that's how we come up with the amount of overcharge plus damages. So that is a brief overview of rent overcharge. I hope that you were able to follow along and got some good information out of that. And I believe we should have time for a few questions.
Thank you, Mr. Dereck. That was very helpful information. We will be sharing the presentation on our website. I know some people asked, so do be aware of that. Some of the questions are just more legal in nature, so I think during Mr. Miller's presentation it can be answered, so I'll hold off on those questions. But for now, what I will start with, I believe someone had asked, sorry, I'm just gonna go up. someone had asked that if the fees were based on, sorry, I'm just gonna go up. If a tenant overcharge is based on fees, do you still get treble damages?
If it's a specific overcharge, no. You would only get back whatever excess fees were collected by the owner. The only time treble damages are involved is if it's an overcharge on your legal regulated rent or collectible rent.
Okay. During the par process where the landlord files an appeal, the tenant who had filed the rent overcharge can't receive treble damages, but they can continue paying the lower rent?
Yeah, well, the way that works is that, as you saw the chart, there was an amount due to the tenant, but we also calculated what the current collectible rent is. So when the par is filed, that amount that was due to the tenant is frozen. But what we said was the collectible rent from the time we issue the order going forward while the par is pending, that's the amount that the tenant would actually pay. So they would still get the benefit of the lower rent, they just could not collect the damages.
Okay. And then we have someone who asks, will DHCR look back further if the claim is for unlawful deregulation or includes fraud on the overcharge?
Yes. As I said before, under Grimm, no, it wasn't Grimm. I'm sorry. I think it was, I think it was Grimm. But bottom line is, yes, if there's an allegation that an apartment was fraudulently deregulated, and this is prior to HESPA, since after HESPA deregulation no longer exists, we will go back, even if it's more than 4 years, more than 6 years, we'll go back to the time that it was actually deregulated, and the owner, the current owner, would have to provide proof that it was a lawful deregulation. We'll ask for the last rent-regulated lease. We'll ask for the first deregulated lease. We'll ask for all of the documentation that the owner relied upon in order to go from a regulated rent to a deregulated rent, depending on what the deregulation threshold was at the time that that apartment was deregulated. And that amount varied over time.
Okay. Regarding the offset, what happens to the money if the tenant passes or dies, unfortunately, before the final payment?
That is something that would probably be up to probate. It's not a question that I could answer. It would go along with any other assets, I would imagine, that the tenant had at the time of their passing.
Okay. How can a tenant go about finding out if their building filed a J51 application or if it was approved for a J51? Usually it's in your lease, I believe, but I don't know if there's any other method.
One of the things they can do is they can go on the website for, I believe, Department of Finance and put in their address. There's a specific part of it where you can look up to see if there are any existing tax benefits on your building, whether it's 421A or J51. And so if you're not sure, contact them. Okay. He just interjected that he's going to go over that, so I'll leave it there.
Okay. Great. Okay, so those are the questions that I have.
Yeah, I see a
and then
few
just
more.
If a tenant moved out, can they collect on overcharge for past payments? And I
Yes,
believe
one thing
that.
Yeah, I think I may not have been clear during the presentation. I may not have mentioned it, but you don't have to actually be a tenant in occupancy to file an overcharge complaint. As long as the overcharge occurred within the window of the look-back period, either 4 or 6 years, you can still file an overcharge complaint as a tenant who previously lived in that apartment at that time. You just would not, if you are determined to have been overcharged, you would have to file it as a judgment once you receive the overcharge order.
Okay. So the other questions, I think it'll be Mr. Miller will answer in his presentation, and we are running a little bit behind, but I do just really wanted to thank you again, Mr. Dereck, for that presentation. That was very helpful information, and I hope everybody can benefit for that. Thank you so much again.
Thank you. I appreciate it.
All right. Okay, so again, thank you to Mr. Frederick. So now we are going to be moving on to our second presenter. We will be hearing from Mr. Seth Miller, who will be talking about the appropriate venue to file a rent overcharge and how to read a rent history. Just a little background information. Mr. Seth Miller is a partner in the firm of Collins, Dopkins, and Miller LLP. His firm has specialized in representing tenants in disputes with landlords and developers for nearly 25 years. Mr. Miller's particular field of expertise is in issues arising under the rent stabilization law and code. He has participated in some of the most significant cases involving rent overcharges, including most recently Regina Metropolitan versus DHCR. So you can take over, Mr. Miller.
Thank you to HCA and to everybody who's attending. I really appreciate the opportunity to give this presentation. And thank you to DHCR for sharing what goes on under the hood. There are three basic legal principles that we are going to talk about that you're looking to apply when you read a rent history. The first is that in basically every apartment in a building built before 1974, if it's got more than 6 units, was at one time rent stabilized. And the first issue is whether any deregulation was legal or not, and if it's still stabilized, whether there's an overcharge. The second issue we're going to look at is whether there's a J51 in place that will make it rent stabilized. And the third issue you want to be able to screen for is whether a past tenant was the beneficiary of a rent reduction order, such as would impose rent stabilization on a continuing basis on an apartment. There's basically two kinds of rent histories that you're going to be confronted with when you deal with clients. One kind is when the apartment is clearly rent stabilized. And that's basically only when it's registered as stabilized as of June 14, 2019, when the HSTPA took effect, or thereafter. And in any other case, you're dealing with a rent history that will represent a claim by the landlord of deregulation, where it's uncertain whether it's lawfully deregulated or not. And one of the key messages I want you to take back with you is that it's a question of risk. You are making a decision, you and your clients are going to be making a decision based on incomplete information. And you want to get as much information as you can. You want to bring your experience to bear on the situation. But any rent history that says that an apartment was deregulated will present a scenario where you will not know for sure whether that's true unless there's a rent reduction in effect or there's a J51. So let's just deal with a couple of simple concepts. Apartments were stabilized. They came out of rent stabilization basically by the rent being raised over a certain threshold. That original threshold was $2,000, went up to $2,500 in 2011. Let me just share the chart. There should be distribution of this material. I sent it to Housing Court Answers, but I'm going to share this chart. This is the, let's see, sharing the screen. There's a chart that DHCR put out that is fact sheet 36 that will give you at different points in history what the deregulation threshold was. And that can be a complicated affair, but you need to know that it's complicated, and you need to know that at some point in the more recent past, the threshold was high enough that in some parts of the city, it might have been difficult legally to deregulate an apartment, right? I mean, there are parts of New York City where an apartment might never have gotten over $2,774, which was the most recent threshold for deregulation. That's fact sheet number, let's see if I can grab that again. I believe it's 36 at DHCR. Now let me get you a rent history to take a look at. This is a redacted one that I have from one of my cases. Let's see, share this one with you. Okay, how do I expand this here? Okay, this is a typical rent history on an apartment that is the subject of a claim of deregulation. And you'll see that before the days when deregulation was allowed, there were typically modest rent increases that were sort of within what people at that time were expecting for a stabilized apartment. So this one went up to $750 or so in the mid 90s, then $790, and so on. And then in 1994, the city council started to allow vacancy deregulation, and then you'll see these drastic rent increases. And here's a concept that you should be aware of right away. So you see a jump like this from $834 to $1040, and then another $600 jump in the course of a year from tenant to tenant. That's two sets of jumps. Now, landlords were permitted during those days in the early 2000s to get a 20% rent increase for a 2-year lease as a vacancy increase. But when you see repeated jumps, it's usually based on the claim of making improvements. And as I will go over, Operational Bulletin, I think it's, 2016-1 will be a source for you to figure out what those increases were. They were at one time 1/40th the cost of an improvement, got added to the rent. Then as of September 24th, 2011, in bigger buildings that went to 1/60th. It's in writing and it's in the documents that we're sharing. But these increases would have been because of claimed improvements. And what you should know as an advocate is always screen for the repeated claim that an apartment would have been renovated over and over again, because that is illegal. It is illegal, or was always illegal, to do the same renovation twice within the useful life of a particular improvement. So a landlord, say here in 1999 in this apartment, might have gotten an increase for putting a new bathroom sink in the tenant's bathroom, but they are not allowed to take a new sink out and put another new sink in and collect a rent increase. The rent increase is supposed to be an incentive to improve apartments and not supposed to be a scam. So you want to screen for those repeated jumps, even though, as I said, you're not going to have, unless you're in court with the landlord or get the information from the landlord, exact and precise information about what it is the landlord claims to have done in terms of renovations. All we know is that you're going to suspect reasonably that large jumps repeated over the years, over and over again, mean that the landlord is probably claiming to the right to do more than one improvement within the useful life of new equipment in an apartment, and that's illegal. Now, there's nothing on this chart that shows that this building had a J51, but it's one of my clients, and it did. There's also no, as is typical in these cases, you're going to find this, right? Many years of non-registration. And in terms of managing the risk of filing an overcharge claim, you want to know whether it is possible that the apartment is deregulated, and that's what your client wants to know as well. But you always have to be careful to interact with your client and deal with their risk. The first rule is to do no harm to your client. And if there's a risk that the apartment was in fact deregulated, and then your client will be the victim of retaliation, you want to make sure that the client knows what they're getting into before they start pushing the landlord's buttons, right? So in this case, we got some more information about this building, because there's this magic line at the end, and you should always look for this. Related cases, HG 210-405S. That is a service reduction case, as Mr. Frederick was talking about. Tenants in a stabilized apartment have the right to complain when where there is a lack of repairs. DHCR will reduce the rent when they find a lack of repairs. Those rent reductions freeze the rent, and the rent freeze does not go away unless the landlord subsequently files another case. And that case should show up here. So when you just see the S, it means it's very possible that there is a rent reduction. And in fact, as it turns out, we investigated, and this apartment had a rent freeze of $900. The last registered rent was $2,301. The tenant was paying closer to $5,000. $900, this apartment, because of this. So you always want, as part of your screening, to file to get, sorry, let me share a different thing here. So this is your request for record access. Let's see, is sharing still on? You guys seeing this? This is a request for access.
Yes,
to public record.
yes. We're still seeing your screen.
When I or some other lawyer uses the phrase get a printout of cases by building, what we mean is that item 8 needs to be filled out, and the top request made for a list of the docket numbers of every case that's ever been filed for that building. So it's a long process, because you're getting this printout, and then you got to figure out what the printout means. Here's a different building. Here's what a cases by building printout looks like, right? So you'll see there's a bunch of rent control stuff. There's a rent overcharge case in the history. The tenant of apartment 10, if that was your client, you'd want to know that it was denied.
So sorry, Seth, we're still seeing the registration apartment information doc. You may have to stop sharing and reshare the screen you're on now.
Let me try that one more time. This is, okay, let's share that. Everybody should be seeing what looks like a very technical printout of cases by building. That's the result that you're supposed to get when you file DHCR's request for access to public records and ask for item 8. Get a printout like this. If you don't know how to interpret this sort of thing, then you may want to talk to a lawyer who does, or an advocate who does. But basically what you're looking for is anything that affects all of the apartments in the building and might have imposed a rent freeze, such as a rent reduction order, an S case, or a B case that's granted. What I mean by an S case or B case is you see there's 2 letters, then 6 numbers, then 2 more letters in any docket number. A B case is one where the final letter is B. An S case is one where the final letter is S. Those are service reduction cases. Or an overcharge case, and we'll talk about overcharge cases, where the tenant was granted an overcharge. Those are the things that you want to look for, because as I said, it doesn't happen in every single case, but if you ever get a client like the one whose rent history I just showed you, you may be looking at a tremendous amount of overcharge, rolling rents down from the several thousands that landlords are charging now to into the hundreds. So let's see some other information about this rent history that we've been discussing. So there's a 4-year rule, and that doesn't mean that you don't want to look at these old sets of facts. It just means that what you want to do is size up the possibility that the rent was legally deregulated. And the longer that period of deregulation, the more likely it is that the landlord is going to win. Because as I said, you're going to be managing risk. Every time during this registration not found period, every time a landlord gets a new tenant, they get another 20% rent increase, right? So you have to be very careful when you about making a claim for rent regulation in a deregulated apartment if the tenant can't afford to take the risk. That said, when you see an entry like this one for 2003, where it's a preferential rent to a new tenant, that's cause for suspicion. And if it's a more recent entry, particularly one within the 4-year rule, you're going to want to use that as a red flag, because for a number of reasons. Very often the landlord will just be charging the tenant the lower rent and register it this way, in which case that's not a preferential rent at all. It becomes the new legal rent. And very often the landlord will mess up how that preferential rent is done. There's some case law that talks about preferential rents that can be punitively applied, where a tenant loses their rent if they pay late. Those have been found to be illegal, and that establishes the lower amount as the legal regulated rent. So you want to look for that as a red flag as well. But your review of a tenant's history is not over until, now we talked about cases by building, but until you look at J51. So let me show you that. And there are two things that you want to look at for J51. Now, should I share this? Do people have this address? I'll share it in the chat. This is where you get your J51 information. I'm going to copy that and just put it into the chat if I can grab the chat. Let's see, where is my chat here?
It's just on the bottom next to.
Yeah, I'm having a little trouble with that. Maybe if I. Okay, I'll try to get that to you guys later. But this open data website is where you look for J51, and I'm going to give you a sample of how this basically works. All it's going to be is a spreadsheet. You're not going to be getting anything that says that any particular address has a J51 or not. What you're going to have is the block and lot and a spreadsheet showing what years the J51 might have been in effect. And we're going to use a famous address, Stuyvesant Town, which is Manhattan, which is borough code number 1, block 972, lot 1. The way to grab that, by the way, I'll just reset this and do this one more time for you guys. So here we are on J51. You hit filter, add a new filter condition, and then you're doing borough code number 1 for Manhattan. You have to know the block and lot for your building. This is 972. And adding a new filter condition. This is lot number 1. And here we are, the famous J51s at Stuyvesant Town that go back along. And if you export this into a spreadsheet, you will have a whole series of J51s that go back all the way to 1992, a very large treasure trove of information. And if you want more precise information, particularly about the ending date of, I see you get it from the top there. The ending date of a J51, you got to go to the New York City Department of Finance website and get the tax bill. And I won't bore you with where you get it, but it is on the Department of Finance website. This is a tax bill from a few months ago. Stuyvesant Town's J51 is expiring. This is what it looks like. Landlords are supposed to pay $13 per apartment for every stabilized apartment. So that's a useful piece of information when you're dealing with illegal deregulation. And right at the end is a bottom line, J51 abatement. I just highlighted it. You're going to want that. You're going to want to know when the J51 began and ended, which is why we started with the open data, because these tax bills don't go back very far. They definitely don't go back to 1992 or even further, because Stuyvesant had a J51 back in the 70s. They only have recent tax bills, but you want to know when the tax abatement expired, so you know whether your client was in occupancy during the tax period. Because if your client was, then it was definitely a stabilized apartment. When you're dealing with a definitely stabilized apartment, the risk assessment is different. You can look at things in terms of, if it's at all suspicious, you can file an overcharge complaint. You don't have to worry about retaliation. You don't have to worry about your client getting evicted or not having their lease renewed just because the landlord is mad because you raised an issue of overcharge. Okay, so where do you want to file your overcharge claim? And there's several choices. The first thing that you should consider, and particularly if, let's see, I'm going to stop the share now. First thing you should consider, particularly if it's a purportedly unregulated apartment, and if your client has a good ways to go before their lease is renewed, is to see if you want to ask the landlord for information that's missing from the rent history. See if you want to ask the landlord, where do you get this rent from? What were the circumstances of the deregulation? It's not 100% the case that a landlord will always respond to an advocate's inquiry or a lawyer's letter asking for that information, but it doesn't hurt. It lets the other side know that the client is savvy, that the client knows what their rights are, and it gives the landlord a chance to convince you that the apartment is as the landlord claims it to be. So don't disregard that as a possible way of dealing with your client's questions about overcharge. And then there are the three major places where you can file, and there are benefits and risks to each one. You can either bring an affirmative lawsuit, You can withhold the rent and let the landlord bring a non-payment proceeding, or you can file with the DHCR. There are only two advantages to filing with the DHCR, and one of them is pretty much negligible. It's free. DHCR is free, right? Your client doesn't have to pay a lawyer to file. We'll probably have to pay the advocate or the lawyer, or at least use the same kind of legal expertise and legal resources as they would in a lawsuit, just to deal with the landlord's attorneys before the DHCR. So that sort of cancels out. The other advantage of DHCR is that the DHCR cannot order your client to pay rent, right? Which also will cancel out, because if your client is worried about being ordered to pay rent, if they're not paying rent, then you're going to wind up before a different forum than the DHCR anyway, because somebody's going to sue for the rent. Withholding rent and raising the issue of overcharge before the housing court has some advantages. It is the fastest method. Litigation in housing court is far faster than going to Supreme Court. The cases are on a calendar. The calendar marches along. Landlords usually push it fairly quickly. The disadvantage is that most people do not like the risk of being evicted. And that risk is present. Those are eviction proceedings. And discovery is limited. If the landlord doesn't give you what you think you're entitled to, even a good housing court judge may deny you the right to that documentation. There are other lesser important disadvantages to housing court too. I mean, if you, for example, if you go up on appeal, if you lose and go on appeal, you often will not be able to go any further than the appellate term, whereas if you were in Supreme Court, you could potentially go all the way up to the Court of Appeals. The last option would be to sue, to bring a lawsuit. And the big advantage there is that you have complete control over discovery. You get pretty broad discovery, although landlords do push back. It is still the official position of the landlord world that you're not entitled to more than 4 years worth of documentation, even though the HSTPA gives you 6. And even though on issues of status, you go back forever, you may end up litigating that issue, but in general, you get all the discovery you need. So to answer some of the questions that have been posted, before the DHCR, you will not be able to smoke out a landlord who pays their cousin one amount and then the cousin kicks back some portion of that just to inflate the bill. That's a tricky thing to smoke out even for a skilled lawyer in a Supreme Court case. But if you really want to be able to do that, you want to be in Supreme Court asking for bank records, asking for all transactions between the contractor and the landlord, subpoenaing the contractor's records, and being prepared to litigate any pushback on issues of getting that level of discovery. You should know that under the HSTPA, you now have the choice of where to have your overcharge claim heard. It used to be that you'd run the risk if you sued in court that the courts, especially courts that don't like landlord and tenant issues, would send you to the DHCR. That is no longer the case. It is now the tenant's choice. If you're having trouble paying the rent, you're probably slightly better off in housing court than in in Supreme Court. But either way, you're going to get into a problem because courts will order you to pay something while the case is going on. Any landlord attorney will make that motion early on in the case. The flip side of that is that it could be an advantage if the landlord's rent claim is completely unsupported. Like I once had a case where the landlord, I sued the landlord for overcharge, and the landlord was a new landlord and made a motion to dismiss the personal, manager and stuff, and said, well, you got to give me time because we don't have any records. We have no records to support what we're charging Mr. Miller's client, which gave me an opportunity, right? Because then I just went to court and said, well, the rent has to be set at the last registered rent because these guys have no records to support anything higher. And I got the rent rolled back to $800 while we litigated my client's overcharge case. So it sometimes can be an advantage to be able to ask a court to lower the rent while you're in court litigating. But in general, if you're in court, you're going to wind up paying whatever it was you were paying before, and the court will make sure you pay it while you're litigating, which is something of an advantage in housing court, only because it's shorter, things are faster, and the rules are very clear under the HSTPA that people do not get evicted for not paying interim rent. All you can wind up with is an accelerated determination of your issues. And okay, so that's what I came prepared to talk to you guys about, and I've been going on for a while. Let me know if there are any questions.
Thank you, Mr. Miller. So we do have some questions. I think somebody was asking if you could clarify the 4 versus 6 rule for overcharges.
Okay, it is a bit contested at this point, but I will try my best. And the reason it's contested is because these rules do 2 things, and you need to discuss them separately. The rule tells you how many years worth of damages you get to recover back if you overpaid. And the rule also sets the rent based on a particular previous rent. First of all, for the issue of status, you go back forever. And that's what the case law clearly says, including the Regina case. For overcharges taking place prior to June 14 of 2019, in the Regina case, the Court of Appeals said that those cases have to be governed by a 4-year rule. So that means that if you file an overcharge today, so you have 2022, you got 21, 20, 19, that's 3 years after. You only you don't get 6 years worth. You get back to the date of the HSTPA and up to 4 years worth of overcharges. So in terms of how much money you can get altogether, you're not going to be able to get 6 years worth of overcharges until the HSTPA has been in effect for 6 years. But the real battle is over how you set the rent. And, here's the reason why we don't like to go to DHCR, because they're bad on some of these issues. Like Mr. Frederick gave an excellent presentation, but it's the DHCR's position that the rule is you set the rent based on what the rent was 6 years ago. Well, that's not what the statute says. The statute says that the rent is the rent reflected on the last reliable rent registration filed 6 or more years prior to the most recent. So if the apartment remained unregistered for 10 years, then that's 6 plus 10. That's not 6. And that's how you set the rents post HSTPA. But the 4-year rule applies to how you set any rent and how you determine any overcharge collected for the month of June 2019 and any month before that, right? And that 4-year rule was very strict. Unless you show fraud, the rent is going to be whatever it was on that 4-year base date, right? And the Regina case showed how strict that that interpretation was, because in my case and in the other cases before the Court of Appeals, they allowed the use of a market rent, right, a deregulated, very high rent, to serve as the base rent for purposes of rent stabilization, because that was the rent in effect on the 4-year base date. So it gets to be a little complicated. The courts have not resolved exactly when you get to use the HSTPA to set the rent and when you use the 4-year rule as interpreted in the Regina case. In my view, the HSTPA applies to rents collected on July 1, 2019 and thereafter. But that's just my view. That's not been decided by any court. And if you were to have some landlord attorney here, in fact, I participated in a panel with Debbie Regal from Rosenberg and Estes, she would say something completely different.
So another question that we had is, what if the tenancy began more than 6 years ago? Are they still stuck with the base date that is in the middle of their tenancy and possible overcharge claims?
Well, if the tenancy started more than 6 years ago, then there's no controversy about the fact that for the first part of that, for the 4-year base date that is going to be a base date prior to the HSTPA, that rent paid 4 years prior to today would be the legal rent from that date until June of 2019. That's clear to everybody, unless there's fraud, unless there's an exception to the 4-year rule. What's in controversy is whether that rent gets recalculated for July 2019 and thereafter, because that's how you would apply the HSTPA prospectively. And Regina said that they're not making any decision about how you apply that statute prospectively. So then you arrive at July of 2019. What would you be looking at? You'd be looking at what is the most the registered rent reflected in a reliable registration from 6 or more years prior to the most recent registration. So you're not, for that July 2019 rent, looking at a date. There is no longer a base date rent under the HSTPA. What you're looking at is a base registration. You're looking for a reliable registration. Courts have not decided who's got the burden of showing a registration is reliable and who doesn't. Courts haven't decided what it means to have a reliable registration. But I showed you a sample rent history, and common sense would tell you that those registrations from the early 90s, where it was modest increases in the, going from 600 to 700 to 750, those are reliable. Nobody's going to challenge those, right? But I would not. I wouldn't tell this question, the person asking this question, to look at the rent on a particular date for those post HSTPA calculations. I would be looking at the registrations. You're muted. Try again.
Sorry about that. Another question was just how can you find out the year a J51 ends?
Okay, so I showed you that that statement. I can share it again. That tax statement. You want to go to the Department of Finance website and look at the tax statements. So you're going to see. Sorry, not that one. This. I'm going to share that screen again. So here's a tax statement, and this is a statement issued in June of 2018 for the quarter of July, August, and September through September 30th of 2018. Right there, these are forward-looking statements. So if the J51 is on this statement, it means that at least through the end of that quarter, September 30th, there's a J51. You want to go through those statements one by one until you see the J51 disappear, right? On the last one of these statements, right, where you see the J51, that's going to be your end date. And that's the only real way to do it. You know, it's not about what was granted by HPD to begin with, or what the landlord says in a J51 rider. It's really about what shows up on these tax statements.
Okay, and just one last question. A person asks, can an article, sorry, I'm just going back. Does an Article 78 become an option after 35 days after an appeal expires?
No. You have to stay in the game at every stage of litigation, and you can't skip the par level and go straight to an Article 78. If you lose some issue at the rent administrator level at DHCR, and you miss your par deadline, you are out of luck. There's no filing an Article 78. You have to go through each step in the appeals process. If you don't miss the deadline, if you actually have a par, then you've satisfied that prerequisite. And if you lose at the par level, then you can bring an Article 78.
Okay, so we do have to move on to the next session, but I do really want to thank you, Mr. Miller, for joining us today. We got some very helpful information. It was an excellent presentation, and I hope that everybody here can utilize this information on your day-to-day work. So thank you so much.
Thank you for having me. And my email address is in my ID over here. Please feel free to drop me a note whenever you guys need. And thanks for having me. Take care.
Thank you. And we will be sharing the presentation. If you weren't able to get access to it, again, we will be sharing the presentation on our website. So please feel free to check that out. But thank you so much to all the presenters today. So for now, what we will be doing is we will be taking a 5-minute break. So before we begin with our second part of the presentation, so it's now we can come back at 3:45. Okay, welcome back, everybody. I'm just gonna give people 30 more seconds to come back. Okay, so now we will move on to the next part of our presentation, which will be on how to help unrepresented tenants by our very own HCA staff, Kayla Popuchet and Alexander Chaparro. They will be explaining how to navigate non-payment cases and holdover cases. Just as a reminder, HCA staff members are not attorneys. We are housing advocates and we share information, legal information, but we do not provide legal advice. So just want to put that out there just in case. So just a little intro. Kayla is a CUNY student, activist, and proud polyglot. She is currently mastering the Russian language. She is passionate about housing justice, labor justice, and sovereignty for Latin America. She is a first-generation Jackson Heights born and raised by Peruvian immigrants. And Alexander joined Housing Court Answers in November 2018 and assisted at the information tables in Brooklyn and Queens and on the hotline. They were born and raised in Caracas, Venezuela, where they received a bachelor's in sociology from Universidad Central de Venezuela. Alexander, a writer and filmmaker, also teaches after-school arts classes in the Brooklyn Public Library. So now I will pass it on to Kayla, Alexander, and Nancy Torres.
Hello, everybody. Thank you for coming. Thank you for joining us. So before we begin with the presentation, I just want to open up real quick with some housekeeping rules. Please, folks, just keep yourselves muted. Same things from like the last presentation that you had. Any questions that you may have, please write them in the chat box. Don't try to unmute or speak during the presentation until asked to, unless you're asked to. I also just want to mention that there will be no tolerance for bigotry, although this may not have to be said. I have experienced some trainings where we were disrupted by language of bigotry. So facilitators will remove anybody that engages in this behavior. We will not accept that this behavior or tolerate it. But without further ado, I just want to begin to introduce you to this workshop. So this workshop presented by myself and Alexander is to share to you guys some of the tips and basic information that can help unrepresented tenants in housing court. So it's not going to be an overly extensive overview of housing court, although we do provide that training, which you're welcome to come to at a later date. But we're mainly going to focus on some of the main defenses and protections that are available to tenants in the most common scenarios in housing court. And I'll pass it to Alexander.
My name is Alexander Chaparro, and most people know me as Chaparro or Chapi. And the theme of our conference this year is defending New York City's right to counsel. But as we are seeing now with the undermining of it by the court's decision, that there are a lot of gray areas in the field of offering protections through assigned counsel. There was in the past, there is now, and there might be in the future. And this presentation is an effort to present our perspective of housing justice as requiring universal solutions and finding the ways and the information that we can provide to tenants now that are facing housing court without an attorney, that can empower them in these scenarios. If you can go to the next slide. So yeah, Housing Court Answers has helped unrepresented litigants in housing court for over 30 years. We started this organization as a citywide task force on housing justice in 1981. It was a group of concerned advocates working in community-based organizations and legal service offices that started 2 task forces to help in the Bronx and Brooklyn housing courts. I remember when I first had my interview with Housing Court Answers, they told me that they help people in housing court that don't have lawyers, but they are also part of the Right to Counsel coalition that is trying to find people attorneys in housing court. And to me, on that first interview and that first experience with Housing Court Answers, my impression was that they were trying to put themselves out of business. Like they're in the role of helping people without lawyers, but their main objective is knowing that they can to empower tenants by getting them lawyers. And to me, I thought this was really inspiring because I think this is a perspective that a lot of nonprofits should have, which is to solve the problem that we are being asked to address instead of just continually perpetuating our existence. So I love and I've always admired the fact that Housing Court Answers is trying to make itself not useful, but as we have seen for the last 30 years, all of the reforms for justice have been reforms and have not been a universal protection that addresses the economic injustices that take place in a court that before this citywide task force was created, had 97% of the landlords coming to court represented and 88% of tenants coming to court without a lawyer. Since the right to counsel has been enacted, we know that 86% of tenants that have a lawyer remain in their homes and avoid forceful eviction or avoid committing to monetary judgments that are unfair and do not correspond to them. Right now, we're seeing this undermining, and this is what this workshop is precisely for, is that even despite them trying to undermine these tools for justice, organizations like ours are committed to helping every tenant that comes to housing court or any person that doesn't come without an attorney to help them. And here are some of the tools or some of the information that we share on a daily basis in our information table and our hotline that helps people that don't have a lawyer. And so if you pass the next slide, I'll pass it to Kayla to talk a little bit more about right to counsel.
So as Chaparro had gone over, yes, we've been heavily involved with the right to counsel. First, before 2017, when it was passed, first trying to get it passed, and now we've been part of the right to counsel, trying to expand on it a little bit further to make it more comprehensive for all the tenants in New York. So while tenants are initially scheduled to the intake part as their first appearance, the court is beginning to merge this with the resolution parts. And so what happens then? Now, let's talk about the beginning. What happens in the intake part? Right now, as of now, the intake part is scheduled to a person's first appearance, in which they will not have a judge in the room. They will not have, likely not have the landlord's attorney or the landlord even there. They get to sit one-on-one with a paralegal or even an attorney that's going to sit there and take in their information, hence intake part. And so just about the right to counsel right now, tenants must earn, to be eligible for it, tenants must earn 200% or below the federal poverty line. But as we know, even if you make $15 an hour and work full-time in New York City, now, even off of that, you're overqualified for the right to counsel. So the Right to Counsel Coalition, what we're doing is we're continuing to fight for an increase to the income limit for the right to counsel. But of course, this is the situation that we're in and tenants may still be able to get advice. Even if they can't get representation, they can get advice from one of the legal service providers with the right to counsel. And of course, they're encouraged to call our hotline as much as they need to get in any information, because obviously because of capacity issues and also because of income issues that may prohibit them, they may not be able to get legal representation. If they can get advice, and they can always call our hotline. Nancy, can you get the next slide? So let's talk about non-payment cases. These are one of the more common cases that you'll see in housing court, and probably a lot of your own people are calling you for this. So what is a non-payment case? It is a type of eviction case that is filed by the landlord to collect on some back rent. So these kinds of cases, the vast majority of them do not end in eviction. And the reason being is that if the tenant can figure out a way that they can pay, then they get to stay. So we say in this world, you pay, you stay. Very simple. If you're unable to pay by the deadline of which you were given, then the tenant can be evicted. Although there are maneuvers to work around that to get some more time, which we're going to go into in a later moment. So tenants do have some defenses, which are reasons why they should not have to pay what they owe. So even if they do owe, let's say, 10 months of rent, there are defenses that say, hey, I may owe 10 months of rent, but I shouldn't have to pay this 10 months of rent. And these are the defenses that are offered to them by the housing court. There's also the Safe Harbor Act, which was passed to protect tenants who owe rent between March 2020 and January 2022 with any COVID-related arrears from possessory judgments. So a possessory judgment, just to say it flatly, is the judgment in which you can be evicted from. It says that the landlord now will have possession over the apartment if you don't pay. So if you don't get it in there, it can definitely prevent you from being evicted, but you will still at some point have to pay that money. It will likely not protect you from a monetary judgment, which is to say that you have a judgment on your credit that you have to pay this money. And so cases in which a tenant has filed for the ERAP application, if you have a non-payment case, you can still use this to put it on hold. So what we often recommend that tenants do when they call to answer, they don't have to do it at the answering moment, but you're at the stage of answering. It's easier to call, and after you've given your defenses or given your answer, then you can give the court and tell them that you would like to also file your ERAP application confirmation number, which will be about six or 5 digits between letters and numbers that'll come in their email once they've applied for ERAP, and they can give that to the court so that there's a stay or a hold put on their case, preventing them from getting a court date until ERAP has made a decision, whether to approve it or deny it. After an approval or denial, then the stay can be lifted. And so if a tenant has applied and does qualify for ERAP, but the landlord did not complete their portion of the application, many tenants have been calling us with these concerns and these worries. Oh, my landlord didn't submit it, and I got the money, but he doesn't want to take it. I'm scared that I'm going to get evicted. But fear not. If you've received a provisional approval, meaning that ERAP has this money for you, but the landlord needs to submit their portion, then the landlord cannot sue the tenant for the covered period's rent, which means if the tenant cannot get evicted for the money that is owed, that is covered by ERAP. Now, that doesn't mean that a tenant can't get evicted at all. If there is still money owed that isn't covered by ERAP, a tenant can get evicted over this unpaid money that the tenant will have to come up with themselves. But if ERAP covers everything that the tenant owes, but the landlord doesn't want to submit their portion, then they cannot be evicted, and they should hold on to that provisional approval letter for dear life. Hold it with them for the rest of their life. Often say upload it to the cloud, upload it to Gmail, put it in your bank vault if you have that. But keep that with you, because that's going to be something that'll protect you throughout the rest of your life. That the landlord had 180 days to accept the money and refused to. We see a lot of landlords throughout New York thinking, oh, well, if I don't accept the money, then the tenant won't be able to pay me the $40,000 that they owe me, and then I can get them evicted, especially if it's a rent-controlled or rent-stabilized apartment. But this is a farce. The landlord is given 180 days to accept the money. If they don't accept it, then that money will go back into the funding program and go to somebody else, and the tenant is still protected. Go to the next slide, please.
So I can talk a little bit about the process and the notices that you usually get on a non-payment case. And this is a start to any case in housing court, documents that you receive or are served to your home. A big part of what motivated us to do this workshop is that we realized that through the work that we do on our hotline, that just by clarifying certain misconceptions about how housing court operates or what are the tenant rights that people have, it becomes already a different, more empowering situation when tenants kind of understand what is actually happening. So for example, in non-payment cases, I know that a lot of advocates, sometimes we avoid calling it an eviction case. It's a civil case to discuss a supposed amount of money owed that could lead to an eviction. But it is a civil case to discuss money. It's not an eviction case. And I say this to talk about something about the notices as well. Most of the times people call our hotline and say, I got an eviction notice. And when most of the times it is actually a notice from court or from the landlord and their attorney. I would like to emphasize that neither of these are an eviction notice. Only a marshal's notice is an eviction notice. So for example, a non-payment case, one of the predicate notice, meaning the notices that the landlord and their lawyers have to give the tenant to warn them about the possibility of a case starting, very commonly gets mistaken as an eviction notice. So for example, if you pass to the next slide, Nancy. This is an example of 14-day notice that someone sent us while we were on the hotline. I cropped it, and on the top of where it says 14-day notice, it said in big capital letters, eviction notice. This is a misleading language and information that is written in this notice. A lot of times these would have a wording that say, if a tenant does not pay within 14 days, they could lead to an eviction. But it's the courts kind of putting in legal terms the possible outcomes for this case, but it's very easily misunderstood by people that this is an eviction notice, meaning that after the 14 days, on the 15th day, someone's going to be knocking on their door if they do not pay this amount of notice. So we want to clarify that one of the things that worries us the most as housing justice advocates working on the phones is the amount of people that would self-evict in these situations, that would get something like this and not knowing that this is one of the first steps in many steps of a process in which they have defenses and they can fight back and they can get time and they can get assistance. They would interpret this as something that is already an eviction. And we want to clarify, and we want you to tell your constituents when they talk about, to kind of clarify the differences in what did these papers really mean. And this paper, the only thing that it means is that the landlord is making an accusation of a certain amount of money that you owe, and that they're giving you this notice to say that they think that you owe this. And unless you resolve this with them within these 14 days, they have a right to bring this document that they provided to you to court to say that they demanded this amount of money, there hasn't been a payment, and now they would like to start a case in court to discuss, emphasis, this amount of money. This does not mean that you owe this amount of money yet, until you get to raise your defenses. So this is a predicate notice, the document that the landlord and their attorney has to send you to warn you about a possibility of a court notice. After that period passes, the tenant usually might get a petition of non-payment and a notice of petition. These are what we call court notices. Again, this is not an eviction notice. But the only difference from distinguishing it from a predicate notice is that now the only thing that this indicates is the case has officially started in housing court. We distinguish these by the title, petition, which is the most common name for these court notices on a non-payment case, but also by the fact that they indicate an index number. You might see in the top right corner, on the very, very top right corner in small details, and on the title, it says index number. Again, if you're a tenant here in this workshop, or you're an advocate that works with tenants a lot, learn to localize these things, because this is the most important information that indicates or distinguishes your case from here to the end of it. This predicate court notice would also have the amount of money that the landlord accuses of and other kind of first accusations or first statements established by the petitioner. At this moment, the instructions for the tenants is for them to answer the petition. A lot of times people say, oh, it says that I have to do this in 10 days or else I'm going to get evicted. Right now, the court is accepting answers over the phone. And we have noticed that throughout the last 2.5 years, they have been much more lenient with this idea of the 10-day notice, because they know that there are lack of capacity to answer all the calls that they're getting. And also another thing that's really important about these notices of petitions, every time someone gets them, they call us and they say, oh, it says 10 days, but it's dated here by a certain date, which is like a month ago. Most of these are dated when the landlord first started writing them up. It only counts those 10 days officially when you receive them. So tell your clients, or if you're a tenant, know that the dates that are usually attached to a notice of petition and a petition are dates that the landlord puts in when they start writing these documents. The only date that actually matters when you received it, and actually the courts are being much more lenient. So if you're 9 days or 10 days after you received it, you still have time. We want to put urge for you to answer as soon as possible. But this is like a lot of these things that we're going to be addressing on this workshop, we notice how by the misinformation, the tenant gets weakened in their strength to respond to these things. So the more that they're clear about the times, the protections that they have, the distance that they can keep between themselves and a possible eviction, the more empowered they are to come to court and fight for the best defenses with empowerment. The next slide, Nancy, please. And this is a typical answer form. If you could pass to the next slide, Nancy, I put a couple of, so when we tell people that when they're answering the petition, it's kind of a moment where the tenant is a chance for the tenant to make an active presence with the court. So it's letting the courts know that you're not ignoring the documents that you received. But it also gives you an opportunity to present one of the first general defenses that the courts can write down when doing the intake for your case. So when they call our hotline with a non-payment petition, what we let them know is call the courts to let them know that you're not ignoring these documents, and take advantage of this time to let them know of any possible defenses that might apply to your case. The most common defenses that we share with our constituents are if there are repairs needed in the apartment, and this might reduce the amount that you owe. A lot of times, and this is something that we discuss with our tenants over the phone, landlording is a service, like a lot of services, like groundskeeping. If you hire someone to offer a service and they do not provide 100% of the service, and they bill you for 100% of the services, you might have an issue with that. So the same thing with your apartment. The landlord does not only have to provide you a roof over your head, but they have to provide you a habitable home and has to respond to your request for repairs. So if they're not doing that, you have a grounds to discuss the amount that they're claiming that you owe on this apartment during this time. You can also let them know if they served you improperly. If they have to serve these documents in a certain way, not on a Sunday, first in person, and if not by certified mail. So if any of these things have not been fulfilled, you can also let them know. Again, let them know if there's anything like a misspelled name or information that is incorrect. And also something we tell all of our clients that are calling us now, let them know if you lost income during the pandemic. The court should know whether you qualify or not for the Safe Harbor Act and whether you applied for ERAP. If you have your ERAP application, give them that number at the moment of answering and let the courts know that you lost income during the pandemic. Hence, that you might also qualify for the defenses presented in the Safe Harbor Act.
So I actually just want to go back a couple of slides. If we could go to the petition. Let me see when you get there. One thing I wanted to point out, which is pretty important, is that if you notice on this notice of petition right here, it says that there are legal fees, right? So the landlord on the petition has to provide a rental breakdown of the arrears that they're claiming is owed. But if you notice on this example, the landlord has included a $750 legal fee. It's important when a tenant responds and answers this, that they point out that they wouldn't actually owe that full amount that the landlord is claiming, because the landlord can only sue for the rent that is owed, not fees. And so often landlords will put in legal fees, court fees, late fees, but the landlord can only sue for the amount of rent that is owed. It's also important that a tenant look and see if what the landlord is claiming is owed is actually the rent on their lease, the rent that they're supposed to be paying. Another thing is that the tenant should also look to see if there's any rent overcharge when they receive this. If they're a rent stabilized tenant, they can go back and take a look and see, hey, actually my apartment had an overcharge a couple of years ago, or maybe even just raise the claim. And then the last thing that I wanted to say on this was the tenant should always take a look at their receipts. And if they're paying in cash, they're entitled to a receipt. That's by law. If they're paying by money order or cashier's check, they should keep their receipts and match it up. Just because the landlord is claiming that you owe all this money, you cannot accept that at face value. They should look up and see what they have paid and what is correct and incorrect. Even if they owe the money, even if they know that they owe some money, oftentimes people end up paying over than what they're supposed to be paying because they don't look at the inconsistencies. So I thought that was very important, especially part of the answering, as one of the defenses is, I've tried to pay, or the amount is not correct, that they point out in this particular petition, the amount is not correct. They don't need to pay the $750 legal fee.
Another thing that, and thank you, Kayla, that also all goes to what we were saying of looking at these documents and responding whether you agree or don't agree, or whether there's anything that you think is mistaken as far as the claims made by the petitioner, the landlord. The other thing I wanted to mention as far as the answers, another very common one that we would help people, or we would see people fill out in the courts and the tables, and when we're talking with them over the hotline, is also the possibility of general denial, which I think is number 16. And that is sometimes when the tenant is not completely certain of all the possible defenses that might apply to their case, and they would like to leave a somewhat open-ended answer that might leave the possibility for a lawyer later or later down in the process to include other defenses that they might not know how to articulate at this first moment of answering. If we pass to the next two slides, the one of the process, once you make the answer, the most likely is that the court clerk might give you a court date for your first appearance, or that you might get one in the mail after you submit your answer. This first court date most likely will be in the intake part. And what we like to let the clients that call our hotline know that they're facing this first appearance is to kind of clarify what is an intake part. And the way that we explain to them is that it's a first appearance in which a judge is not going to be present because nothing is going to be decided on your case at this moment. Similar to the answering process, this is a day where the main purpose is to make an active presence, to take information from both parties involved in the case, and in theory is the moment where a tenant should connect to a free attorney to do intake to see if they qualify for the right to counsel. We're letting our clients know that if the attorney is not there on that first day, they should let the courts know, possibly ask for a postponement of that intake process, and to call us to see if they possibly could get an attorney through the Universal Access Program or through an OCJ referral. After that first intake part where the information is taken, another court date is established that would be for the resolution part. This is another thing that we take a lot of emphasis in our hotline to clarify to people, and something that maybe Kayla was talking about earlier, that most of the cases in housing court don't end in a trial. They don't get resolved through a judge's decision. A judge doesn't want to have to rule in so many issues coming in front of them. They're going to want you to reach a resolution, a stipulation, an agreement on both sides. So we let the tenants know that most of these cases go in this direction. So it's most important to have the strong arguments of how you would want to negotiate, and the things that are weighing for your benefits in that negotiation, and the grounds that you have to ask for the things that you're asking for. But to not think of this as like the images that people have in court TV of presenting the evidence and exhibit A, exhibit C, and trying to convince a jury of something. They can go that route, but sometimes we suggest against it, because whatever decisions made on a trial can have a very quick demand of either money or possessory judgment, and they have less of a possibility to extend through order to show causes or make extensions on times like you would do normally in a resolution part. As the slide says, in a resolution part, there will be a court attorney as well, a court officer. So there are other people there aside from the possible free attorney that could possibly give you as a tenant assistance if there's something that you don't understand, if you're, as we were talking before, a stipulation that you don't agree and you want to pause before you agree to anything. In the intake parts, it might be through video screens. They say they're moving in the future, like Kayla was saying, most of these intake parts are going to go straight to the resolution part. So there's going to be even less of a chance for tenants to connect to free attorneys, and more of an urge for them to be prepared for the case in their first appearances. But for now, the intake part is still in effect, and letting people know that, you know, sometimes they're virtual, sometimes they can be in person. And if you have doubts about that, to make sure to call the court clerks to get all the instructions about how do you have to appear. So I'll pass to the next slide, and Kayla's going to talk about the possible outcomes in a non-payment case.
So the resolution part, as mentioned before, is where the stipulation, or stipulation is just a fancy word to say a settlement agreement is made. So if the settlement will happen in the resolution part, and this is where we encourage tenants to, as I said before, use collective bargaining to really negotiate. I think all New Yorkers have been to Canal Street before. You go down, you find a pocketbook that you like for $50, you try to haggle them down. You have this experience, you can do the same thing in housing court, although it may not be. So it's a little more precarious in housing court, but still use those skills to negotiate with the landlord, or something that is more reasonable that you can actually comply with. But if both parties cannot reach an agreement, then that's when the case will maybe have to move to trial, and it will be appointed a new judge, a trial judge, that will look over the case. It is important that a tenant consult with an attorney before deciding to move to trial, because their consequences are pretty severe. If they lose, they can risk having to move out or to pay what they owe in just 10 days before a marshal's notice is served. So it is very essential that they speak with an attorney. Even if they can't get representation, they can still get advice. And so that's just about the stipulation. So again, a tenant is encouraged to try to haggle, to try to negotiate, and we'll talk a little bit about that in deeper in the next slide. But again, if the case moves to trial, that means that both parties could not reach a settlement agreement. Another thing that could happen is that the case will be dismissed. So this is if the landlord hasn't done the papers or the case right. Or what does that mean? It means that if a landlord has done something improper, whether through service, whether through the filing, or actually just messed up on filling out the paperwork itself, then the case will risk being dismissed by the judge. And so it's important that when you're helping a tenant, you'll want to make note of all the inconsistencies with the laws, as this can help a tenant get the case dismissed, whether that be the name change, whether that be the improper service, whether that be improper information. We'll talk about this a little further, but if the predicate notices don't give the allocated time that they're supposed to, then they can also risk dismissal over that. Another possible outcome is that this case could get discontinued. So what that means is the landlord has decided to drop the case, maybe because the tenant paid, maybe because the tenant's already moved out. But for whatever reason, the landlord has decided to drop the case. And then what adjournment is, or getting the case adjourned, is that it is moved to a later date. This could be because either party, maybe both, maybe one or the other, has for whatever reason asked the judge for some more time, maybe to seek legal counsel, maybe to get more time to prepare, but they can ask for an adjournment to get the case moved to a later date. Next slide, please. So let's talk about stipulations. This is very important because most cases, most cases in housing court are resolved through stipulations. So the stipulation, as we said, is the settlement agreement. And the courts would rather a tenant settle than having to go to a trial. Most people experiencing a housing court case for the first time don't know this. They definitely have the image of, law and order, we're going through trial, I need to get my evidence together, but most cases actually just go through a settlement agreement. And tenants should use this as an opportunity when making a stipulation to lay out exactly what they want from the agreement as well. Yes, the landlord wants you to pay 10 months of rent, but maybe the tenant wants something from the landlord. This is when the tenant can, ask the landlord to provide some of the repairs or some of the services that are needed, and also have put in a clear set of dates of when the landlord comes to do this, so that they can know when the landlord is there, and they can know to either take off of work or, reschedule a doctor's appointment to be there. And also, if the landlord does not come to do the repairs on that date that is established, either they come on another date or they just don't come at all, then the tenant can come back to court and file an order to show cause to put more pressure and possibly increase the fines and violations against the landlord for failure to comply with the stipulation. The tenant can also, in the stipulation, allocate for enough time for them to apply for rent arrears assistance. At least before COVID, we would always tell tenants it takes about 45 to 60 days for a one-shot deal to go through, for a decision to be made. So when tenants are making a stipulation agreement, they're going to want to give themselves at least 2 months and a half before they're expected to pay everything. 30 days to pay $5,000 is asking a lot of New York's working class that, most people cannot come up with that money in that short of time, also while being expected to pay the rent that's already ongoing. So this is the opportunity that a tenant has to say, okay, maybe I'll pay you $500 on top of my rent every month until the arrears are off. Or, hey, give me 3 months and then ERAP and one-shot deal and another charity will come in and the arrears will be paid off. This is the opportunity for a tenant to make an agreement with the landlord, put in the repairs that they needed, or possibly other issues that they want to get into the stipulation. Some examples that we have where people come into a non-payment are because they have a subsidy and the landlord didn't fill out the documents that they needed. So they can put in the stipulation, the landlord will submit the documents. Or if the landlord never gave a lease renewal, they can put in, the landlord will give me a new lease so that they can apply for back rent assistance. Or if a tenant is being harassed and the reason they stopped paying rent was because of harassment or the repairs, then they can put it in the agreement. The landlord will make the repairs or the landlord will stop harassment. And that way they have a legal document that they can come so that if the landlord fails to comply with this, they can come back to the court and put more pressure on the landlord. And if for any reason the tenant is feeling pressured to sign an agreement, sometimes landlords will come to court, especially if they don't have a lawyer. They'll come to court with a pre-made stipulation and say, here, sign it. You have to sign it or you're getting evicted, and really put on the pressure. It'll be the landlord's attorney and the landlord putting pressure onto the tenant, and they don't have to sign it. They should not feel like they're forced to be signing anything that they cannot comply with. And if that's the case, they can ask for the court attorney to come and to mediate. Now I'll pass the next slide to Alexander.
So yeah, in non-payment cases, it's important to distinguish that there can be judgments included in the stipulation. And those judgments can be, for example, a money judgment. If, in that first moment of resolution, there's a discussion of the amount of money owed and there's an agreed upon amount, there can be a money judgment that the landlord can use to collect that rent. There can also be a possessory judgment put in as language in the stipulation, meaning that if a tenant does not pay by a certain amount, they can use that as something they can take to the marshals to enforce an eviction. But again, the way that it's written now, you can find it so that if money is paid, the possessory judgment goes away. And having said this, it's kind of important, and if we go to the next slide, Nancy, to kind of think about like the main things that we would want to remind ourselves when negotiating a stipulation of a non-payment case in housing court. So one thing that is really important for tenants to know is that there is a possibility of avoiding putting a money judgment in a housing court case. That can be, for example, if it's dismissed on the first day, like Kayla was saying, all the money is proven to have already been paid. Or another way that we normally see this is the tenant has a way to prove that the money is very quickly to be paid. So meaning like, hey, I already have the money, I'm waiting on the next paycheck, or I just started a new job. Some way to prove that the amount can be paid by a certain date. And again, there is a possibility, but it needs aggressive bargaining. And for that, it would be much more powerful if the tenant had that ability to show that they have an ability to pay. And in those cases, we see that it's possible for them to, at the very beginning, say that put language in the stipulation that, for example, says that they will pay by July 15th, 2022. And when that does, the judgment will be vacated. It will be taken away from public record. This is important to know because these monetary judgments are the things that can affect credit in the long run. And it's a way for tenants that go through housing court for them not to have more extenuating consequences after the housing court case is over. We do want to make note that there is something called the Tenant Blacklist that has to do more with just the fact that a tenant appears in housing court, and once the case in court is already calendared in a non-payment case or in a holdover case, when they get calendared from the very beginning, already that person's name appears in housing court, and from our experience working on the ground, a lot of people get denied housing in New York City, even though it's illegal to discriminate on someone because of having appeared before in housing court. We know that still is a common practice in housing court. And it's even in New York City, and it's even worse outside of New York State, where there is no law against the discrimination for appearing in housing court, where people are flat out told that they're not going to get an apartment or a home because they have a record of them in public court. And we can talk more about this at the end in the Q&A part, but we wanted to take advantage of that, at least the monetary judgment that can affect credit. If at the moment of negotiation, we can take advantage of this moment to ensure that possibly we can take the monetary judgment out for the tenant, because that could help them at least with their credit. Also, language of notice of eviction can be removed from a stip also if the tenant has a strong argument saying, I'm going to pay by a certain date. I don't want there to be even the word, oh, a notice of eviction will be issued if there's a default on the payments. And that can just continue to give more protections to the tenant. Again, it requires very strong argument or bargaining for you to have that strong stipulation that gives you protections as a tenant. Again, the tenant should ask for better terms if they know they can't pay on time. Like Kayla said, if they say, hey, on the first stipulation, this person's going to pay $2,000 by July 15th. If the tenant knows that they can't pay by that time, they should ask the stipulation to be rewritten so that it includes a period of time for the payment that is feasible, because you don't want that precedent established of defaulting or asking for extensions from the very beginning. Again, they can ask to review the stipulation with a court attorney before signing, with a translator or an interpreter as well. No one should sign something they don't understand. When we're in the housing court tables, they can come to talk to us before signing anything, and know that, again, you're signing something and you should not sign anything that you don't agree with completely. And another really great rule for negotiating non-payment cases, stipulations in housing court, is that you should take advantage, like Kayla said, that it's also an opportunity for the tenant to put in the conditions that they want to demand of the landlord. So if there are repairs needed in the apartment, the silver lining of a non-payment case is that it could be a very effective place to discuss repairs that are needed in an apartment. It can also be discussed a lease that is needed to be signed, a written lease, or other conditions that you want the landlord to agree. It could be to stop harassing. It could be to establish a certain accepting money orders as form of payment without any form of resistance. Things that, if there has been forms of abuse from the landlord that you've experienced, and this is very common in people who are going through non-payment cases, a stipulation would be a good place to write them down. And our strongest suggestion is to make sure that those things that you put in the stipulation that are demands to the landlord have clear dates, and because that would make it a stronger language on your stipulation. For example, we see a lot of stipulations that say the landlord should repair as required by law. This for us is weak language, because that is something that the landlord should be doing already. The landlord should be repairing as required by law. Stronger language would be the landlord agrees to repair the sink on the first bathroom on July 19th at 2 p.m. because both parties said that there was available for that date. Why? If you have a clear date and a clear thing that needs to happen on that date, if the landlord doesn't do it, you can use that as argument on your next day of court, or you can even come to court, present an order to show cause to put even greater pressure on the landlord to do those things. But we'll talk about those strategies with the order to show cause a little bit later in our presentation. And I wanted to say that we worked in partnership with the Center for Urban Pedagogy to create this booklet called Housing Court Help that has a summary of these tips of how to negotiate in housing court. It's going to be part of this presentation. We also have information documents on our website that talk more about judgments, possessory judgments. They talk about the difference between money judgments, possessory judgments, and their possible effects on tenants, their credit history, or possible other consequences. So I invite everybody to take some time to read more about judgments and these tips on how to negotiate in housing court, because they can be very, very, very strong tools for a tenant to understand when they're coming to these moments of negotiation, especially when they're on their own without an attorney. I'll pass to the next slide that Kayla's going to talk a little bit about holdover cases. That is the other most common form of case in housing court.
All right, thank you. So, oh, sorry, my thing got a little bit behind. So this is the predicate notice as was stated. Now, some of the first cases, oh, sorry, I'm keep going backwards. I'm on the wrong spot. All right, so as I'm sure many of you are aware, the good cause eviction bill would help all tenants, but especially unregulated tenants have at least the modicum of the same rights as rent stabilized tenants in allowing them to stay in their homes so long as they do not violate the lease. But as it exists right now, there are little protections for unregulated tenants. And so many of them are witnessing themselves experience holdover cases. So a holdover case is a type of eviction case filed by the landlord to get the tenant out of the apartment. Now, this could be something that other than the rent is the issue. But one of the things that I find often working in the Queens housing court, where a lot of people live in either private homes or basement apartments or even subleasing, is that rent is the central issue. And the landlord or prime tenant will then just say, no, I want them gone. They're not paying the rent. They pay me what they owe me and they need to leave. This is where a good cause eviction would come in and help and say, hey, if they pay, they can stay. And it gives people the right to stay in their homes, stay in the places that they've built a community in. Now, though, although the holdover case is supposed to be something other than where rent is the main issue. So tenants can still even raise defenses on these types of cases just to explain why they should not be evicted. And we'll go over to that in a little while, but just to talk about the different types of housing that determines whether or not a tenant can be evicted, there's obviously rent stabilized or rent controlled tenants have the most protections. And it's a lot harder for a landlord to try to start a not holdover case against them to get them out of the apartment. There has to be specific instances of violating the lease that the landlord makes a record of. They have to send a notice to cure. The tenant has to not cure. It's a lot much more difficult to get out a rent stabilized or rent controlled tenant. Although it is possible, it's a myth that it is impossible to get tenants out or that it's very difficult to get tenants out in New York. It's a landlord method. They'll also say, tenants have all the rights, we have no rights. That's absolutely not true. And the people who know that all too well are unregulated apartments, where essentially there's a no grounds case. They have no grounds to stay in the apartment. And so the landlord here does not need a good cause to start the case. The tenants in these situations, if they do not have a lease and it's a market rate apartment, or if it's a basement apartment, if it's just unregulated and they don't have a lease, they need to start working out a move out plan. Because at the end of the day, in some way or another, the landlord is going to get possession over that apartment again. Now, there are some general defenses that people can look for when starting a case, when the holdover proceeding is started against them. So they want to get evidence to disprove an allegation that maybe the landlord is saying, you're running a business, or this isn't your primary home, if this is a rent stabilized tenant. For other tenants, though, they can use that there was improper service, or perhaps there's repairs, the lack of habitability in their apartment, or even in these scenarios, we'll see retaliation. So this could be retaliation over starting a housing court case against the landlord for repairs or harassment, which are legally protected rights, as well as calling 311. This is a big one that we see people in unregulated apartments face the retaliation that the landlord is going to start a case against them for calling 311. Calling 311 and getting violations in your apartment is also a legally protected right. Now, you'll definitely need a good lawyer or somebody to argue. You'll need to do a lot of arguing, but to argue retaliation can get you at least another year in your apartment, although that'll take a lot of work, and we definitely recommend speaking with an attorney on that regard. Next slide, please.
So just like we were talking before about predicate notices that people on non-payment cases, it's very, very common for people to call our hotline to say, I got an eviction notice, when it's actually a termination notice. And a thing that's very important to understand is that everybody in New York everybody who has a tenancy in New York has a lease, even though they might not have a written lease. If they don't have a written lease, everybody has a month-to-month agreement that gets automatically renewed, an oral agreement. And so a lot of times people call on our hotline and say, oh, no, I don't have a lease. You do have a lease. It's just an oral agreement that gets renovated every month. So that will continue to be the case unless the landlord formally ends your tenancy. And a holdover case is, as the word says, is when someone is holding over past the official termination of a tenancy. So tenants continue to have these month-to-month agreements, and the only way that it can be officially terminated is through these notices that give a tenant either 30, 60, or 90 days notice to let the tenant know that the landlord no longer wants to continue to keep renewing this month-to-month agreement, or the end of your written agreement, they don't want to renew it. That's why it's very important what Kayla was saying earlier about the differences between unregulated apartments and rent-regulated apartments. Rent-regulated apartments have the strength that they have a right to a lease renewal. So they cannot get a notice of termination unless there is a good reason why they do not want to renew the agreement. In unregulated apartments, that's the main difference. They don't have a right to a lease renewal. So at any moment, a landlord can present this letter without having to give any reason why they don't want to renew your month-to-month agreement. I wanted to take a moment to think of what the fundamental difference that this makes for the type of housing that we're providing to people. In a rent-stabilized apartment, you're basically telling someone that even though they don't own this home, own the physical ownership of this place, this is their home, and it's going to continue to be their home for the rest of their lives or until they decide to move out. They even have right to succession, so it can be their family's home even after they pass away. So this is actually giving what I think most of us in this room would understand, the real idea and concept of a home, of a protected home. So until we pass that good cause eviction, people who don't own property are going to continue to be at the whim of the for-profit interests of the people who own the property that they're in, and their right to housing will be dependent or will have very little protections. So a housing court, a holdover case starts, again, this is a predicate notice. Doesn't mean that after 30, 60, or 90 days, someone's going to be knocking on your door asking you to leave. The only thing that can happen after these 30, 60, or 90 days is that the landlord can come into court and ask them to start a case to discuss this possible holding over of the lease. So if we pass to the next slide. So again, similar to the non-payment case, after that period of the notice of the predicate notice passes, which in this case is the notice of termination, remember that in the case of the non-payment, the predicate notice would be the rent demand letter. Once those periods that are warning the tenant of a possible case, once that period passes, what the tenant would usually receive is the notice of petition and petition, when the landlord officially went to court and requested a case to start. In the case of a holdover, there is no calling the court to issue your first defenses and issuing an answer. There's usually a first date for an intake already established. And similar to what we were saying in non-payment, this is the moment where a tenant should connect to an attorney representing the right to counsel to do intake to see if they qualify for free representation. And again, if the attorney is not there, we're instructing tenants to possibly ask for an adjournment, let the courts know, and call us as soon as possible to see if we can assign them an attorney. And again, the last thing I wanted to say, that like Kayla was saying, there are defenses in a holdover case, whether in an unregulated or a non-regulated apartment. In an unregulated apartment, eventually the landlord would be able to regain back possession of the apartment, but still defenses about the conditions of the apartment, about possible harassment from the landlord can still be brought even on these cases where there's supposedly no defense is possible for the landlord, for the tenant. And I say this because these defenses can get the tenant at least the protection of having enough time to move without feeling pressure or pushed out. So even if you're in an unregulated apartment, you're being brought to a holdover, you can bring examples of new employment that you're seeking out as possible new sources of income that will help you to move, possible listings that you've been looking. You can present information about your job, your family's school, to show that the places that you need to move have to correspond to either your child's school semester or to be close as a commuting distance. And I think somewhere in the law, the way that it's articulated is that that a tenant shouldn't be asked to move in a significant way that affects these conditions of school and work. And in theory, a judge in a housing court case is allowed to give you an extension on any moving plan as long as you prove that you are doing every effort possible to try to move while still corresponding to something that you can afford and something that can respond to where you go to work and where you go to school. If it's a regulated apartment, you can have all of those arguments to get more time to move, but also you can put in the arguments of what they're saying your violation of the agreement is and the reason why they didn't want to give you a lease renewal. Because if you are able to dispute that, you would, again, like we were saying, get the right to a lease renewal and be able to dismiss this holdover case altogether. So the next slide, Kayla's going to talk a little bit about the strategies that we can use with an order to show cause in a holdover case to get more time if we're under the pressure of moving.
So basically, what is an order to show cause? Well, it's just a form. It's a form that you're going to get from the housing court clerk or a tenant will get from the housing court clerk to get an extension, or essentially to bring an order to show a good cause as to why you need a new court date, so that maybe you need to relitigate the stipulation or the agreement. Oftentimes we see people doing orders to show causes if they need more time to pay, need more time to move, or maybe they missed their court date, maybe they failed to comply, maybe the landlord failed to comply. So it's a form that is very versatile. It has multiple uses, but it's essentially if you want to bring, if you have something that you want to show to the judge as to why XYZ needs to happen. And so when doing an order to show cause in a holdover case, you're going to want to show the judge a good reason as to why you didn't do what you were supposed to do in the stipulation, and explain how you're going to fix that, how you're going to comply with the stipulation going forward. And it's essential, especially in some boroughs where it's a little harder to get them approved, like Queens. It's essential to show proof and documentation. So some of the reasons why someone might file an order to show cause, of course, is if they received a marshal's notice. We're going to talk about that later, but it's not the end of the world if you've received a marshal's notice. It's actually pretty common and we can stop them to explain why they missed their court date. I actually spoke to a gentleman earlier today in the Queen's Court. He missed his court date. We did an order to show cause. If they need to get more time to comply with the stipulation in a non-payment or holdover. And if the judge signs off on the order to show cause, that means that there's going to be another court date to determine what kind of relief that the tenant will get. And that could be relitigating and making a new agreement about when they're going to pay or when they're going to move out. The landlord will be notified of the court hearing because the tenant will have to serve one copy of their order to show cause, the papers that they receive back from the court, one copy to the marshal, if there's a marshal in the case, and one copy to the landlord or the landlord's attorney. Now, if a tenant has exhausted their options of getting an order to show cause approved, they should take note if anyone in their household is a senior citizen or has a disability, a recorded disability. So if they can ask, they can ask for their case to be referred to Adult Protective Services. What this will do, so if there's a marshal's notice, it's Friday afternoon, the marshal's coming Monday morning. That's it. What they can do, and they have somebody that's a senior, they have someone that's disabled, and they get their case referred to APS, this will grant them another 14 days before an eviction be carried out, unless APS decides that they will take the case. But once the case is referred to APS just once, it cannot get another referral. So you can only do this once. This is why I give the example. It's Friday evening, marshal's coming on Monday morning, then, get the case referred to APS if the order to show cause keeps getting denied. And in the meantime, in the interim of those 14 days, maybe the tenant can find a new apartment. I've had a situation like that where a tenant found a new home within those 14 days. Or maybe they find some more time to stay. Maybe they get additional proof so that they can do another order to show cause to get approved. There are various reasons as to why a tenant might do an order to show cause or why they might need to get a case referred to APS, and it's not over until it's over. So next slide, please. So this is an example of an order to show cause that a tenant will file because they failed or know that they cannot comply with the stipulation. So they can do this. Let's say, for example, they're supposed to pay today, June 8th, and they know that they're not going to be able to pay on June 6th. They can still file it before June 6th, or they can file it today or after. They can still file the order to show cause. They can file it even after a marshal's notice has been served. So if a tenant needs more time to explain, more space to explain their situation, look at the lines. They're so short. They only get a few boxes to check off, and people's lives are pretty complex. And so you're going to need more space to write. Often you'll see us writing on the margins, or you can use that bottom space of page and a half so you can write a deeper explanation. You'll want to provide a lot of information. You'll want to provide a lot of documentation to support that so that you can get this order to show cause approved. And I'll pass it over to Alexander.
And yeah, it's really important that we spend some time on the order to show cause because it's the most amount of work that we would do when we were on the tables in our information tables in the Brooklyn, Queens, Manhattan, and Bronx Housing Court is to help people file order to show causes. And that's why it's important to make people understand that a case in housing court is not, most of them are not ending in a final judgment and trial, but actually it's a stipulation, it's an agreement that can be revisited. So there is a lot of strength in having a good, strong language in that initial stipulation, because later on, you might have to renegotiate these things. You can file an order to show cause in a non-payment case. For example, if the landlord didn't do the repairs, you can come into court and ask the courts. It's basically a document where you're asking the judge to review new information. So in this case, you can let them know if the person didn't come to do the repairs. That can mean even a greater discussion of the abatement because they're not fulfilling the repairs that they're doing, or to put more pressure for the repairs to be made. You can also bring an order to show cause if you agree to a payment plan and you're reaching the end of that payment plan and you have maybe payments that have been partially made, efforts, and there are maybe possibilities of further income coming in the near future. You would want to apply that to see if you can get an extension. And for that, we will talk about now about the possible documents you can add to that. You can also introduce it, like Kayla was saying, in the holdover cases, if a marshal's is already on the way. And we see this a lot. For example, people that are at the marshal stage and that's the first time they hear about the case. They haven't been getting documentation about the court case. You can stop the marshal's notice and let the courts know that you haven't had a right to present your defenses in court, that all of this happened without you being properly served, that you didn't know about this case. And at that moment, we can stop because you have a right to present your defenses if they are making the argument that, for example, you were defaulting, you didn't show up, but it was actually, we see this a lot where the landlord might be withholding the mail or the tenant that never finds out about the case. If the judge approves of the order to show cause, a new date will be established and these new information and new stipulation will be modified or created apart from that next court date. And the next slide. And these are some of the documents you can bring. It's also very important to bring these documents photocopied, issues of paycheck, job letters for upcoming employment. It can mean previous payments that you've done. It can be agreements, commitment letters from community-based organizations that are willing to help. And this is something that we're going to pass on now. We're going to talk about getting help on non-payment cases from charities, because this is another of the work that we do when we connect to people who are starting in these cases, is letting them know that there are many organizations, community-based organizations, that are there to help with non-payment cases, and they can use that in a stipulation or in order to show cause to show that there's hope of resolving the issue, and that can give them more time in a stipulation. And there's also public programs like the one-shot deal with HRA, ERAP, and other forms of rental assistance that the tenant between one court case and the next can apply and come back to court to show all of these efforts that they're doing to secure the resolution of the case. And all of this is just giving light at the end of the tunnel, or hope. And as long as you have ways to prove that you're doing the effort and that there's hope, you should be able to get more time, or we're going to fight with you to try to get them more time and to get those lights of hope within their case. And Kayla, would you want to talk a little bit more about the documents?
Yeah, so
I think we said a lot about this already.
Well, it is vital. I just want to say one thing. It is vital to provide 2 copies of each document that you will receive. So because one copy will have to go to the landlord and another copy will go to the judge. So if they do not submit 2 copies, if the tenant filing the order to show cause with their documentation does not submit 2 copies, the judge will not see the documentation, and they risk having their order to show cause denied on the grounds of no documentation to corroborate their claims, even if they provided 1 document. Another thing to mention is that these documents will stay on file with the court. So the tenant should not submit any originals unless they are willing to secede them from their possession forever. Now we'll go quickly to the next slide. So this is a holdover order to show cause, and this is where the tenant will likely be asking for more time to move. So the tenant must be ready to provide proof that they have been looking for a new apartment. So this may be that they've applied and they continue to get denied for new apartments, or they're facing source of income discrimination or any kind of discrimination, which of course is illegal, and they can mention that in court, but at the end of the day, they're still going to have to find a new home. So it is very much a catch-22. Unfortunately, so many tenants throughout the city face. Now, it could also be that they got a new lease, and I worked with a gentleman like this last week. They got a new lease, they're ready to move in, but the building or the apartment that they're going in is still being fixed from the last tenant. It's going through renovations, which delays the process, which delays their access to moving into the apartment. So they should come in with proof that they have a lease or any kind of communication with the new landlord. I've worked with people where they've gotten letters from the new landlord that notarize it for them, and then they just print it out and bring 2 copies of it. And they can just mention any other barriers that they might face with getting a new apartment. So the tenant should be ready to provide a written explanation on their order to show cause, explaining all the reasons why they need more time to comply. And the documents are meant there to support these claims. The court asks for a good reason, which are some of the reasons that we've listed, just as best and as detailed as they can. And they want to see that the tenant has actually made new attempts to secure new housing, but it's something outside of their control. Another thing could be that the tenant, like Alexander said before, is they're getting a new job, or even something as small as they're still working with a realtor, and they can just bring, I've worked with people like this, they just bring the business card of the realtor, and we make a couple copies to show this is the realtor I'm working with. Please just give me some more time. We're looking for a home. It's difficult to find an apartment, especially in this economy. So it's important just to bring any documentation and the best foot forward that a tenant has.
And on that note, I'll talk a little bit about apartment search support that you can have, that you can also bring in an order to show cause and a holdover that can help tenants in the process of looking for a new apartment in the hopes of finding a resolution or a solution to a holdover case. And I want to make a note that we started a little bit late on this part of our online workshops as part of the annual conference. We're gonna go through the next slides a little bit quick, so we end right at 5, and we give at least 5 minutes to do Q&A, possibly 10 if people want to stay over and they want to discuss anything. So I just want to go quickly that similar to getting help with rental arrears in a non-payment case, In a holdover case, there's also community-based organizations that can help tenants find a new apartment. Imagine how hard it must be for a tenant that is not very common with the internet and computer access to look for listings. There's a lot of community-based organizations that can help you look for those listings. Housing Ambassadors is one city program that helps people apply to apartment lotteries. Home sharing is a program that connects senior citizens that might have an extra home in their apartment with people who are looking at home for a room. So it could be a good way for someone to find housing, or for someone to find extra income if it's a non-payment case. So that could help in that as well. Resources to help with moving expenses, so they can connect with us to help them connect to the One Shot Deal, Bridge Fund, and other community-based organizations that can provide economic support in their moving efforts. And they can also keep in mind that if they are facing income discrimination because they have a Section 8 voucher and they're searching with that and they're having difficulties, there's organizations like We Unlock that is helping. And let's go quickly for whatever we're... the next slide, Nancy. So yeah, and like we were saying before, all these efforts that prove that you're doing every effort possible to reach the solution of the stipulation, meaning finding a place to move, realtor's notes, realtor listings, realtor business cards, etc., etc. All that can be used to present the order to show cause. And a marshal's notice, the same way, we can present an order to show cause to stop that. Like I said before, a lot of people hear about their cases at this stage, and we can put a stop to that if that's the case. If APS is needed to be called, that can be a way to stop the marshal's notice. If there's, for example, a possibility that there's going to be a move-out date or a final payment or some sort of resolution before those 14 days of the marshal's coming, again, we can put a stop to that so the tenant doesn't have to go through that traumatic experience, and can put a stop to them and move on their own accord. And there's a lot of information here that if you're an advocate, you're working at a community-based organization, and you get a marshal's notice, the most important thing is to check the earliest eviction date, call the marshal's office to make sure that they don't have anything scheduled. You can find that in the top right corner of a marshal's notice, and let the tenant know that they do have more time, and base your strategies about applying an order to show cause or contacting legal services based on the information about how much time they have. And the next slide, Nancy. Yes, and next slide after that. And there's other types of evictions. There can be foreclosures, ejectment actions. It can be vacate orders. And we can also help in these situations. They're less common situations in housing court, but our hotline is there to assist. And I think the next slides are about getting rental assistance in housing court. And that's similar to what we were talking about, getting light, getting hope in the case for the tenant to solve the issue that they're going through. If it's a non-payment case, you can get economic help with these community-based organizations and programs that the city provides for tenants, and we can help connect with that. And if it's a moving effort, we can also help with that as well. Or if it's having to fight back legal inaccuracies or improper services or improper legal actions, we can also help with that to push back. Here are some examples of programs that help with rental assistance through HRA. Some are ongoing rental assistance, and some are one-time assistance to help pay back rent. But all of these, and applying to them, and letters of commitment or proof of having applied to them, all of that can get good standing in court and can give us more time, or can help us negotiate a stipulation better. The next slide. And yeah, this is our hotline, and we help Monday to Friday, 9 to 5. We speak multiple languages, and we have a strong connection to language services, so we're able to connect to a wide array of people. And I wanted to end it with a message that we were giving initially, and I'll ask Kayla if she has any other closing thoughts too. But again, we see the power in information, the power in empowering tenants. So when they call our hotline, we usually talk about two types of energies. The energy that freezes people up, like you're in the headlights, and the energy that gets people moving to call our hotline to find a solution to what we're doing. We want to let people know that there are defenses, even if they don't have an attorney, even if this is the first time experiencing something like this, there are rights, and the more rights that you know and that you know how to connect to, the more empowered you will be to face this very intimidating situation. But there's organizations like ours to give you support. Kayla, is there any last thoughts before we go to questions?
Hi folks. So Kayla is in court and she had to step out of court. But thank you, Chaparro, so much. And then I'll pass it over to Nipa so that she can close us out.
Okay. Thank you, everybody who presented today. It was great to see new and old faces today. Just really quickly before everyone leaves, I posted a link. The Rent Guidelines Board are currently deciding what the rents will be, and we are facing one of the highest increases since the de Blasio administration. So you can testify. So I posted the link on how to register. They're being held on June 13th and June 15th. So please feel free to register and testify. I just want to thank all the presenters, Alexander and Kayla, you did a great job, and our other presenters, Mr. Frederick and Mr. Miller. Again, it was nice to see everyone. These presentations will be on our HCA website and our YouTube page, which I will send in the chat. And again, if you have any questions, please feel to reach out to our hotline at 212-962-4795.
Thank you, folks. I'll be posting a link for our in-person part of our annual conference for tomorrow. So feel free to welcome us at John Jay from 2 p.m. to 5 p.m. We'll have a panel on right to counsel with the Office of Civil Justice, judges, housing attorneys, and tenant organizers.